As a reminder, a power of attorney is needed in the event one becomes incapacitated. The incapacity may happen as a result of either a disease, such as Alzheimer's or a stroke, or as a result of a car accident. The power of attorney document allows your agent to make financial decisions on your behalf, to deal with banks, real estate, IRS, lawyers, and Medicaid. New York has a statutory form for the power of attorney. It means that the financial institutions do not have to accept forms that were not statutory. So it is very important that this form is the correct one. So, what is included in this document? What do the various sections mean? Here, you, the principal, will name your primary agent to make financial decisions for you. This is the primary person who will be responsible for making decisions in case you are incapacitated. Here, you, the principal, will name your success agents to make financial decisions for you, in case the primary person is not available or declines the appointment. You may name more than one person to be the agent, both as a primary agent and as a successor agent. You can also decide whether they can each act independently or they have to act jointly. We usually recommend that you name one person at a time, or at the very least, allow them to act independently. Otherwise, many banks simply refuse to accept the form, as they don't know how to deal with two people having to be present simultaneously for every decision. Here are all the powers that you are going to give to your agents. You will initial by the letter P to confirm that all the powers above are allowed. Clients are always asking us, do I have to give all of these powers? Can I pick and choose? The answer is yes, you have to give all of them, because no one can predict which ones of these powers are going to be needed. If a power was needed but it was not initialed properly here, the agent will not be able to act on your behalf. For example, they may not be able to sell real estate. In that case, since circumstances may actually require it, the agent will have to go to court to get a guardianship order. This process takes 4 to 6 months and costs over $10,000, and the results are not guaranteed, and in the meantime, everything is frozen. People have lost hundreds of thousands of dollars as a result of not initialing all the rights. Here is an additional power that you are going to give your agent, the right to make gifts from your money. People get horrified. Why would I want to do this? There are 3 reasons why this power is crucially important. First, if you have a catastrophic illness and need to qualify for long-term care, then the agent will need to be able to transfer your assets out of your name to qualify you for Medicaid. Second, if the above is not relevant to you, but your assets are high enough to make your estate subject to estate taxes, your agent may need to transfer your assets out of your name to reduce the estate tax burden. Last, but not least, if you have been supporting your spouse or your children or your grandchildren during your life, the agent may want to continue doing so during your incapacity. This power allows the agent to transfer money out of your name, but only based on your overall estate plan, specified in your will or your trust. They cannot give money away to random people. Here are some additional powers that you are allowing your agent to have. There are 36 of them. They range from additional tax planning, to compensation for an agent, to choosing your place of residence, to online accounts. Again, a lot of these may not be relevant to you right now, but since we cannot predict the future, we strongly suggest that all of these remain as a potential power for the agent. The next section is monitor. If you would like to name a monitor who will be supervising your primary agent, you can name them here. Clients are always asking us about the ability to change one's mind later about an agent. Remember, this power of attorney can be revoked by you at any point, as long as you have the mental capacity to do so. It will be automatically terminated at the moment of death. You will sign this document in front of a notary. The 2 witnesses will sign it right after you. They have to see you sign. Your primary and successor agents will need to sign this document in front of a notary as well. It does not have to be done simultaneously with you. It can be done later, in any US state.